What is non-disturbance in commercial real estate leases? The concept of non-disturbance is a critical, although often misunderstood, element within the framework of commercial real estate leasing, specifically concerning the relationship between a tenant, a landlord, and the landlord's mortgage lender. At its core, a non-disturbance clause is a contractual assurance given by a lender to a tenant that the tenant's possession of the leased premises will not be disturbed, for example, terminated, if the landlord defaults on its mortgage and the lender chooses to foreclose on the property. Without this protection, the general rule of law in many jurisdictions dictates that a mortgage that was recorded before the lease would have priority, meaning the foreclosure would automatically extinguish the subordinate lease. Consequently, non-disturbance serves to effectively reverse this common law priority, allowing a commercially viable tenancy to survive the financial failure of the landlord. The primary objective of a tenant in seeking a non-disturbance agreement is to safeguard the significant investment of time, money, and planning that goes into securing and building out a commercial space. A business, particularly a retail or industrial operation, may invest millions in leasehold improvements, specialized fixtures, and supply chain logistics based on the long-term stability provided by a lease. Should the landlord face foreclosure, the loss of the lease would translate directly into a catastrophic financial loss for the tenant, forcing a costly and disruptive relocation. Therefore, non-disturbance is an essential prerequisite for any sophisticated commercial tenant, offering crucial continuity and risk mitigation, especially in long-term leases with substantial capital expenditure requirements. The non-disturbance clause is rarely standalone. It is typically packaged with two other key provisions to form a subordination, non-disturbance, and attornment agreement. Subordination is the tenant's agreement that its lease is subordinate to the lien of the mortgage, often necessary to satisfy the lender. Attornment is the tenant's promise to recognize and accept the new owner, the lender or a successful bidder, as its new landlord following a foreclosure, and to continue paying rent. The three parts are intrinsically linked. The tenant agrees to subordinate and attorn, but only in exchange for the lender's reciprocal agreement not to disturb its peaceful possession. This tripartite agreement harmonizes the potentially conflicting interests of all three parties, tenant, landlord, and lender, creating a stable legal environment for the underlying commercial venture. From the lender's perspective, providing non-disturbance is not merely an act of benevolence, it is a calculated business decision. A lender that forecloses on an income-producing property relies on the existing revenue stream, the tenant's rent payments, to maintain the property's value and service the debt. Terminating a lease, especially that of a major anchor tenant, would severely diminish the property's income-generating capacity and reduce the recovery value upon a subsequent sale. Therefore, lenders will usually grant non-disturbance to creditworthy tenants with market-rate leases as a means of preserving the asset's value. The resulting subordination, non-disturbance, and attornment agreement is thus a sophisticated tool that protects the tenant's occupancy rights while ensuring the lender can step into the landlord's shoes and maintain the property's economic viability. To learn more about our commercial leasing legal practice, visit our website, or contact our law firm to schedule a confidential consultation. Thank you.